You're tuned in to Agriculture Today, and we start our Wednesday show talking about a blog article with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, this article is titled Rights of Co-Tenants, and as we're talking about co-tenants and co-ownership, how does that sometimes happen?
Well, it happens often when we see estate plans done for farmers and ranchers, and it may be a pretty simple estate plan, and maybe the parents wanted it done this way. It's not the suggested approach, but sometimes clients want to do things that they just want to do, and so you do it for them. And what I'm talking about is where you leave farmland in co-equal ownership to multiple children. So if you have 4 children, for example, the farmland would be owned, and each child would have a 25% undivided interest in the entire farm. And that can lead to problems down the road.
And an Illinois case highlighted issues that can create.
Well, yeah, not just with respect to the farmland itself, but with respect to subsurface minerals that are left in co-equal ownership, and that's what that case involved.
What issue did you see between these two trusts that dealt with mineral and surface?
Well, there were a couple of trusts that were created as a result of estate planning for this family. So you got 2 different branches of the same family owning interests in 2 separate trusts. And one trust had a 50% interest in the mineral estate and farmland, and it claimed that it had acquired the other 50% interest held by the other trust by adverse possession, which is an interesting claim. We don't see it come up too often with respect to minerals and the subsurface estate. We see it all the time in agriculture with respect to the surface estate. And the trial court issued summary judgment for the one trust saying, no, they did not adversely possess your minerals, so you win on that one. And they filed a counterclaim for that trust, filed a counterclaim for accounting, claiming that the other trust, the parties that owned the other trust, that had removed and sold oil and gas from the mineral estate without the other trust's knowledge or consent, and that the title insurance company falsely issued a title insurance policy declaring that the trust that went ahead and developed the minerals had merchantable title to 100% of the minerals in the mineral estate. So the title company was acting on the basis that this trust had adversely possessed the other 50% of the minerals and issues a title policy to them saying, you own 100% of the minerals. Well, as you can imagine, the other family members that held the other 50% interest in this other trust were upset about that. And so they sued. They sued the title insurance policy for slander of title. They sued the other trust on the adverse possession issue. And it just was a huge mess.
And is there a point where that trust could have adversely possessed all of those rights?
Well, the court never really got to that issue, but I'll address that issue for you because it may come up on remand. So there were a bunch of procedural moves in this case. The case is not over. It's going to go back to the trial court on remand because what the court said here was, and you have to pay attention to this in each state, there is a specific procedure with respect to mineral rights in terms of a state law that has to be followed if you're claiming the ability to use those minerals as an undivided co-owner. If there are split interests that are involved here, these fractional interests, these undivided fractional interests in mineral estates, many states have a statutory scheme that has to be followed to get approval for one co-owner to start developing those minerals. And that's what they said wasn't done in this instance. So on the remand, they've got to go back through this to see if those statutory requirements are triggered. But they never really got to that adverse possession issue at all. I wish they would have, and maybe they will on the remand.
And so we're talking about Illinois, but what does this mean for Kansas?
Well, every state has its own adverse possession statute, and Kansas has its unique statute on this, and it's fairly typical of many states, but it says that you can't adversely possess or you can't claim title, let me phrase it that way, to somebody else's property unless you have been in open, exclusive, and continuous possession of that property, either under a claim knowingly adverse or under a belief of ownership for a statutory period of time, which is 15 years in the state of Kansas. Now, Kansas does not have what's known as a hostility requirement. Other states will include a hostility requirement in their adverse possession statute. In other words, without permission of the true owner. So that's not in the Kansas statute. So once you satisfy the elements of the Kansas statute, this open, exclusive, continuous use of somebody else's property for 15 years, and they don't stop you from that, then you could file a quiet title action in the district court to have the title reformed to the property to reflect the area that you were using adversely to the other owner. So that's how the statute works. Now, the question that wasn't raised by the court is, well, will an adverse possession statute apply to minerals, subsurface interests in the property?
And does it apply to minerals? How does you think that might play out?
Well, it depends. That's an interesting question, which I went ahead and raised in my article and answered it to my own satisfaction. We'll see if the court addresses this issue. I hope they do, because we don't have a whole lot of case law on this issue. But when you separate out the mineral estate, the mineral rights from the surface rights, so we're talking in terms of minerals, oil and gas and metals and so forth, you do get this question of how does this requirement of an adverse possession statute, where you have to have open and exclusive use that's contrary to the true owner. In other words, it's the true owner can see that somebody else is using their property and the true owner doesn't do anything about it. How does that work with respect to minerals that you can't see? The only way you would know that somebody is adversely possessing your mineral rights and using them contrary to you is they are using them. They are developing them. In other words, you can't just say that I own your mineral rights because I have owned the surface adversely to you for 15 years, therefore the minerals come along with that. Well, no, that's not necessarily how this works. So just simply acquiring title to the surface doesn't necessarily mean that the subsurface minerals are adversely possessed. There has to be exploration or exploitation of the minerals that satisfies the adverse possession statute. But if you actually go ahead and, depending on your state law, but if you actually go ahead and start developing those minerals, that'll start the clock running on the adverse possession statute. So it's an interesting question. It doesn't come up that often, but that's what we would have to look for to satisfy an adverse possession statute is actual usage, actual development of the mineral estate.
For people who own the mineral interest, is there a way they could protect it?
Yeah, as a mineral interest owner, to protect yourself against a possible adverse possession claim, just go ahead and lease them out to an active company. I think that's a good approach because that's going to establish that you have started a viable use of the mineral rights that is ongoing. That can't be adversely possessed against you if you are the one that has started to develop the mineral estate. But just not developing it could potentially open it up to an adverse possession claim, though unlikely, because if you see somebody that started to develop your mineral interest, you're going to say something. You're not just going to sit there I would assume you're not just going to sit there for 15 years and not say anything with somebody else developing your claim, so to speak. So it's an interesting question. We do have a lot of mineral estates and subsurface estates that have been separated out from the surface estate, and that's another thing that you would have to have here. You would have to have a separation of the subsurface estate from the surface estate and development of that subsurface estate for the possibility of adverse possession to apply.
And Roger, as we kind of bring our conversation full circle again, wanting to mention estate planning and really, as comes to this topic, really important for people of the older generation to think about for their younger generations.
Right. Well, that's how we got this Illinois case to begin with, was by virtue of estate planning. You ended up with farmland that was co-equally owned by different people of the same family and actually a couple of branches of the same family. And you could have minority interest owners that are asserting their rights. So, for example, if I have farmland and 4 children and I leave my farmland co-equally to all the children, they each have an undivided 1/4 interest in the farm. Well, if there's a tenant on that farm, I had a tenant is there after I pass away. 3 of my children want to continue the lease, but I have one that doesn't, the one that has a 25% undivided co-equal ownership with their siblings, sends notice of termination. Is that effective? When they only have a 25% interest, well, they have 3 siblings that have the other 3/4. The answer is probably no in that situation, although I'll tell you there are court cases that are surprising on this that can cut the other way. Just don't do that from an estate planning standpoint. There are other ways to address that problem of satisfying a goal of many parents to treat the kids fairly or treat the kids equally. And equal and fair don't mean the same thing, and that's another topic for another day. But just leaving the farmland equally to the kids generally is a bad idea.
And Roger, if people would like to read more on this blog article or other articles, maybe learning more about estate planning, how can they do that?
You can access my blog by virtue of my website, which is washburnlaw.edu/WALTR. I also share these with Ag Manager at K-State.
Roger, I appreciate you taking the time to join us today.
Thank you very much.
That was K-State and Washburn law professor Roger McEowen. I will link his article, Rights of Co-Tenants, in today's show notes on agtoday.net.